All right, let's get right into it. If you're prepping for the bar, you know that some cases just stick out. They're the ones you absolutely have to know. Today, we're tearing down one of those cases, Shaw versus the Deputy Commissioner of Taxation. And look, don't let the tax part fool you. This case is a complete masterclass in civil procedure, and it's all about how to keep your client's case alive.
So it all kicks off with this huge number, nearly $1 million. This was the personal penalty a company director was ordered to pay the tax office. It was a knockout blow, handed down without a full trial. But that order was overturned on appeal. And understanding why that happened is going to be absolutely crucial for your exams and honestly for your future practice.
So here's how we're going to break this all down. We'll start with that $1 million problem, set the scene. Then we'll dig into the director's dilemma and that first brutal judgment. After that, we'll get to the good stuff, the appeal, how they spotted the fatal flaw in the first ruling, and we'll wrap it all up with the key takeaways you're going to want for the bar.
Okay, so let's paint the picture here. The directors of a company, STL, suddenly find themselves in a world of trouble. They're staring down the barrel of being held personally liable for almost $1 million in unpaid company taxes. I mean, this is the kind of thing that gives directors nightmares.
So you've got two directors, William Shaw and Dale Rablin, and their labor hire company, STL. Now the problem? They'd done what they were supposed to do. They withheld the pay-as-you-go tax from their employees' wages, but they never actually passed that money on to the tax office. And you can bet the ATO was not about to let that slide. They wanted their money, and they decided to go after the directors personally to get it.
To really get your head around this case, you have to understand the two key legal rules that are basically going head-to-head here. This is the core legal tension, the thing you're definitely going to be asked about.
All right, first up, you've got this thing called director penalty liability. And let me tell you, this is a seriously powerful weapon in the tax office's arsenal. Its whole reason for being is to pierce the corporate veil and make directors personally on the hook for the company's tax debts. The law is basically screaming at directors, pay the tax or shut the company down, pronto.
But, and this is a big but, directors aren't completely defenseless. They have a shield, the reasonable steps defense. A director can get out of that personal liability if they can prove they took all reasonable steps to make one of three things happen: pay the debt, get an administrator in, or wind up the company. This defense, right here, is the absolute heart of the Shaw case.
Now, at first, things looked really bad for Mr. Shaw and Mr. Rablin. The tax office went for summary judgment, and they got it. Now, this is a total legal knockout punch. It means the court thought the director's defense was so flimsy it didn't even deserve to go to a full trial. They lost before the real fight had even begun.
So what was their defense, you ask? Well, the directors argued that they did take reasonable steps. And this timeline, which comes from their evidence, shows they spent months just desperately trying to refinance the company's debt to get the cash to pay the ATO. They weren't just sitting around, they were actively trying to fix the problem.
But the judge in the first instance, he was having none of it. He looked at their evidence and basically said it was too vague, not good enough. He famously concluded that it fell a long way short of establishing a real, arguable case. And bam, summary judgment for the ATO. I mean, just a devastating loss for the directors.
But it wasn't over yet. The directors appealed, and their argument was simple but powerful. The primary judge had made a fundamental error. He had demanded way too much from them at this early stage. He had, they argued, completely misunderstood the question he was supposed to be answering.
And this brings us to that second huge legal principle you need to nail for your exams, the test for summary judgment. Under the rules, a court can only throw a case out this early if the defense has no real prospect of success. The key words there are no real prospect. It can't just be weak, it has to be hopeless, or as the rule says, merely fanciful. That is an incredibly high bar to clear.
And this is the absolute crux of it. This is the money shot for your exam notes. The Court of Appeal took a look at what the primary judge did and found a fatal flaw in his reasoning. This is the part of the judgment you need to know inside and out.
The judge's error becomes crystal clear when you compare these two questions. He basically ran a mini trial right then and there. He asked, has this defense been proven on the evidence I have right now? But that's not the job on a summary judgment application. The correct question is, does this defense have a real chance of being proven at a proper trial down the road? The first approach decides the whole case way too early. The second just decides if there's a case worth hearing at all.
The Court of Appeal pulled out this key precedent, a case called Canty. And the logic there is just perfect for explaining the reasonable steps defense. It says a director can reasonably choose one path, like trying to refinance, and go all in on it. They don't have to be trying to do everything all at once. It's a sequential process, not a concurrent one.
So here it is in a nutshell. The big mistake was blaming the directors for not putting the company into liquidation at the exact same time they were still reasonably trying to save it. The Court of Appeal said no, that's the wrong way to look at it. As long as refinancing was a reasonable path to go down, they were entitled to go down that path.
So let's wrap this up. What do you really need to take away from all this? Let's boil it down to the 4 key principles you need to have locked and loaded for the bar exam. Pay close attention here. First off, the hurdle for summary judgment is incredibly high. Your client's defense just needs a real prospect. It doesn't have to be a surefire winner. Second, that reasonable steps defense is sequential. You can try to save the company before you have to kill it. Third, the evidence at this early stage doesn't have to be perfect. It just has to show the defense isn't some fantasy. And finally, number 4, you can use Shaw to contrast with cases like Roche, where the directors did absolutely nothing. Shaw is the perfect example of the difference between having no defense and having a defense that just deserves its day in court.
And really, that's what this case leaves us with. It forces you, as a future barrister, to think critically about that razor-thin line, the line between a defense that might be weak and one that has no real prospect of success at all. Knowing where that line is and knowing how to argue it for your client, well, that's a question you're going to face for your entire career at the bar.